In this lecture, I would like to briefly cover some of the major legal concerns and ethical concerns that arise with two major judicial doctrines and their application to the case of non-discrimination and same-sex marriage in the United States. LGBTQ plus persons account for about 2 to 4% of the population, according to self-reporting in a lot of the most recent surveys. This figure does vary from time to time, but they stand as an interesting test of the value of democracy, the quality of democracy, and kind of raises some of the issues that we think of with the tyranny of the majority, the ability of the majority to decide the rights of the minority. And LGBTQ persons are not like other minorities, religious minorities or racial minorities. They do not have federal protections. The House of Representatives is in the process of trying to change this, as we have discussed with the Equality Act. And prior to the decision that legalizes gay marriage, you had the case of United States v. Windsor in 2013, where the Supreme Court ruled that the federal government had to honor same-sex marriages the same as heterosexual marriages. This was the first step in what actually became the sort of final overturning of any statute that prevented equal recognition of these marriages. But between Obergefell and Windsor, there were 60 challenges to higher courts to same-sex marriages launched in the states. And in addition, there were a lot of attempts by local councils to pass ordinances that prohibited discrimination against LGBTQ persons, as well as these efforts to sort of push back against what was clearly becoming legal gay marriage. In addition, once you had the passage of Obergefell based on the 14th Amendment, and that there was the denial of due process and equal protection under the law, a lot of legislatures at the state level and other politicians and local government leaders began to propose legislation, either religious freedom restoration legislation or anti-discrimination ordinances. And this was a very dramatic situation. Probably the most dramatic act was taken by the Chief Justice Roy Moore in Alabama, who basically issued orders to his state to not honor the ruling. But you had other officials in Arkansas, officials in Kentucky, who were also kind of standing firm that they would not follow this judicial ruling. The map that I have screenshotted here and put in my presentation shows really how the breakdown of states who have passed non-discrimination laws and those who have not. An interesting figure here is that 71% of U.S. square miles have no protection for people who are LGBTQ in the workplace. This map shows the breakdown nationally and at the level of municipality of ordinances or laws that protect against discrimination on the following bases. The deep purple are ordinances or laws that protect against discrimination on the basis of sexual orientation and gender identity. The blue refers to discrimination against those on the basis of sexual orientation. The lavender refers to protection of gender identity. The deep blue refers to protection of sexual orientation in public and private employment. The sort of grayish purple refers to gender identity discrimination prohibited in public and private employment. Fuchsia refers to sexual orientation protection along with gender identity in public employment. The teal refers to sexual orientation discrimination protection in public employment. And the light gray refers to sexual orientation and gender identity unprotected as classes against discrimination. The article for today deals with the constitutionality of laws like Hester's law. There are quite a number of states that have attempted or have actually passed these types of laws that essentially prevent municipalities from recognizing civil rights that the state statutes do not recognize. And this becomes a heated political battle in Fayetteville, Arkansas in 2014 when they passed an LGBTQ protection clause. And this was repealed in a special election. And they responded by trying to pass a different form of this law. But essentially, when Bill 202 was introduced to the legislature and passed, this prevented them from pursuing that anymore. And again, multiple states have adopted or have attempted to adopt very similar laws that make sure that local municipalities, big cities, are not able to override the state policy on LGBTQ discrimination. These laws have not very affectionately been labeled anti-discrimination laws. This article is weighing the pros and cons of applying either the political process doctrine, or the dormant commerce clause to the question of anti-discrimination policies. So this is really a question of which strategy is the most likely to win. Beginning with the political process doctrine, which means a government restructuring affecting a minority group and only that group's equal representation in the political process. In Romer versus Evans in 1996, the Supreme Court ruled that a Colorado statute that prohibited local municipalities from passing protections for LGBTQ persons was unconstitutional. They said that this was so because it was a violation of the Equal Protection Clause under the Constitution. However, this clause has not been applied to recent laws like Hester's law. And the basic principle is that fundamental rights may not be submitted to a vote. They depend on the outcome of no elections. That was Justice Kennedy. The political process doctrine is what we call judicially created doctrine. There is no specific language in the Constitution that establishes this. From the standpoint of Supreme Court rulings, this is a combination of equal protection plus the First Amendment clause. First Amendment clauses, really. In a recent decision, 2014, Schuett versus Cole, this process clause has actually been limited to cases where political restriction was intentional. And this is a case that relates back to a Michigan law that banned the use of racially sensitive admissions preferences by universities. And the Supreme Court has confirmed that this is a legal statute because it doesn't intentionally stop political activity. And so for this reason, the writer that we're reading in this article doesn't really believe that there's a lot of hope with this sort of dismantling of this clause, that you can apply it to the LGBTQ plus population. Essentially, there are two major obstacles to applying it to this population. The first is that some people consider this a request for special treatment because it has not been proven to some people that the sexuality and gender identities represented in the LGBTQ community are immutable characteristics, that people have perhaps a choice, and maybe this isn't the same as race or gender. Another issue they point out is that how this is interpreted always falls back to who occupies the Supreme Court, because it is a judicial doctrine and therefore it is subject to judicial interpretation. And given the current constitution of our Supreme Court, this isn't very likely to be applied in the same way that it was back in 1996. The Dormant Commerce Clause holds that essentially private discrimination against individuals in public settings is illegal, and that Congress has the ability and moreover the duty to regulate activities like this. Congress has been given broad authority under the Constitution to regulate commerce between states, and discrimination, segregation laws that prohibited black people from using the same accommodations as white people, these were seen as impacting the aggregate of states, meaning that, you know, one state has a poor policy and it actually creates a problem with the entire economic flow of the country. And the ability to regulate commerce is, to some degree, also given to states within the 10th Amendment. So the Supreme Court has ruled that there are certain conditions where the Dominant Commerce Clause does give power to the federal government to regulate laws within states about commerce. The federal government then can invoke this clause anytime state regulations discriminate against or somehow regulate interstate commerce. This means that if a state is creating an isolationist atmosphere for its own economic gain, it cannot do that. That was sort of the original purpose behind this clause. But you find that in the cases of the Religious Freedom Restoration Act and the case of the North Carolina transgender bathroom regulation, or Georgia's attempt to pass a similar regulation, that instead of building up the state as economically an advantage over its neighbors, it actually is doing the opposite of that. And the writer here says that the federal government has jurisdiction over that as well. And of course, if you have rampant discrimination in one of these states, it's going to impact commerce because certain types of businesses won't operate there, but also individuals' lives will be impacted. They won't be able to do business in those state lines if they're LGBTQ plus persons, in spite of the fact that they may have family there. They may have lived there their entire lives. So there is plenty here to sort of rely on an idea of the Dormant Commerce Clause being invoked, very similar to the way that it was invoked in segregation cases. So just to conclude, I wanted to talk about the Religious Freedom Restoration Act and its status as a state law in the United States. Originally, this was an act passed through Congress and signed into law by Bill Clinton in '93. It was ruled unconstitutional. Look at the Flores case if you want to read about why. And several states have responded in the years since, especially in previous years, with passing their own state legislation that reflects the principles in the Religious Freedom Bill. And essentially what this states is that the government cannot interfere with the practice of one's sincerely held religious beliefs. And this has been reworded since the Obergefell decision to include discrimination against LGBTQ persons. Of course, it isn't written that way. It's written in such a way to state that a person can withhold services or refuse to cooperate in activities that violate their beliefs about traditional marriage and the traditional family. Those are the most extreme versions of this bill. So 21 states have passed this through legislation, and an additional 10 states have had court decisions that have affirmed this as a law within their states.